Bill. And the question is that Part 1 stand part.
Mr Chairman.
Honourable Phil Goff.
Mr Chairman, it's a night for it. Mr Chairman, this is Part 1, and the most important clause in Part 1 is the Purpose Clause, which acknowledges the ongoing serious effects of serious violent offending for victims, and of course everybody in the House would acknowledge that as a matter that we need to address. And secondly, it empowers the court on an application by the victim to make a non-contact order prohibiting the offender from having any form of contact with the victim. Mr Speaker, both of those goals are worthy of support, and the Labor opposition has supported the first reading of this bill. But in the first reading of this bill, sir, we made it very clear that there were some fundamental flaws in the bill that needed to be addressed by the Select Committee. And the first flaw was a huge flaw. It said that you could make an application for a non-contact order as long as the person who had, for example, raped you had been sentenced to 5 years imprisonment or more. If, however, that person had only been sentenced to 4.5 years, you got no protection under this bill. Now, Mr Chairman, you are the Member of Parliament for Invercargill, so you'll be familiar with the case that led to this legislation being introduced. And it's worth mentioning to the House that the gap in the system was highlighted by an unfortunate young woman who had been raped and the offender had been sentenced. The offender had been sentenced, sir, to 4 years. That offender, having served the period of the prison sentence he was required to, then moved in next door to his victim. Can you imagine how that young woman felt about that? To wake up every morning knowing that you are likely to confront in the street outside your own home the person that had been jailed for raping you. That was not a fair go. And there was nothing that that woman could do about the situation that she was placed in. There was a clear gap in the system. But I asked the question in the first reading, and I raised in the committee, the Select Committee, the question of why, and I think Kate Wilkinson raised the same question actually in the first reading, why ever should there be a threshold set at 5 years? Where did the figure come from? I suspected it was an arbitrary figure, and I think the evidence is, Mr Chairman, that it was totally arbitrary. And then the Select Committee, listening to the submissions that Labor made on this, said, OK, let's lower it to 3 years. And I said, 3 years, fine. Where does that figure come from? And there's no answer. That too was an arbitrary figure. So, thinking back to the Sentencing and Parole Acts that I'd been Minister of Justice for in 2002, I thought, well, in the Parole Act, there is a threshold level of 2 years. 2 years which differentiate a less serious from a more serious offence. And why? How does it differentiate? For example, if the offence is more than 2 years, a sentence of more than 2 years, the person will then come before the parole board before they can be released. There was a threshold that was already established in law. If you're sentenced to more than 2 years, you're likely to be on the victim notification register. So it seemed to the Labor Party that we needed a threshold of 2 years, not 5 years, that the Minister had introduced this bill saying that 5 years was going to solve it, and the rhetoric was flourishing in the House about how important this was, and when the Minister was confronted with the fact that the legislation didn't help the very person whose case had sparked the need for the legislation, basically she had nowhere to go. So I'm happy to report back to the House that what we did in the Select Committee on the instigation of the Labor Party in reducing that threshold to 2 years makes a big change. The size of the change can be seen from the information that we elicited on it. At a threshold of 5 years, this non-contact order was estimated to affect 10 people a year. 10 people a year. Now, I don't have the figures for the number of people that have been the victim of sexual violation each year, but it would run into the hundreds, maybe even more, maybe into the thousands. And the legislation, as the national government introduced it, was plainly inadequate, but that aspect of the legislation has now been repaired in the bill, as reported back, Mr Chairman.
The Honourable Philip Goff.
And to that extent, this is a better piece of legislation. It was a victory for the Labor Party, but most importantly, it was a victory for common sense. Now, the second thing that we were concerned about with the bill as introduced by the Minister was that you couldn't apply for a non-contact order until after the inmate had finished his or her sentence and had been released. And before the Select Committee, we heard evidence from people who had been victims of efforts by the offender to contact them from within the prison walls. Now, Corrections Minister should have dealt with that. They should have dealt with that. But this would have provided another protection if a non-contact order had been available for the victim. But even more importantly, there was clearly a difficulty that when the person was released and before the victim could get a non-contact order, there was going to be a space of time where the victim might be confronted with that offender either close to where he or she lived or where she or he worked. And it made sense to us in the Labor Party that the non-contact order should be available not from the release of the inmate into the community, but from the time of sentencing the inmate to the prison sentence in the first instance. And again, it was a victory for Labor and a victory for common sense that we were able to get that change. So in two really important ways, this legislation has been strengthened, as reported back to the House, and better meets the purpose set out in Clause 3 of this bill. The third issue, Mr Chairman, I've got to give some credit to the New Zealand First Party for, as well as the Labor Party, and that is the question of where the offender used a surrogate to apply pressure to his victim. Where the offender approached a third party and said, I want you to contact this woman and say such and such. And we needed to have a way in which a non-contact order could be made to apply in those circumstances to a third party. Now, you have to be careful in the way that you do that, and we've set certain standards that have to be reached before a non-contact order can be applied. One is that the offender must have asked the third party to take this action involving the victim. The third party, secondly, must have acted on that instruction or request, and thirdly, that must have affected in a negative way the victim, and you could well see why it would affect the victim negatively. So the third change we were able to get was that a non-contact order can apply to a third party, and that also is sensible. Mr Speaker, the last point I really want to make is the question that still worries me a little, and that is, to get a non-contact order, the victim has to file an application in the civil court. And what worried me, and I know Andrew Little, when he spoke on this at the introduction, expressed concern about it as well, is what cost does that impose on the victim that might be unfair? Will there, for example, be a filing fee for a non-contact order? That's a question, Minister, perhaps that you could just clarify. I don't think we've had an answer on that. If you can get an answer from officials, that would be very helpful. The second is, will the victim have to secure the services of a lawyer in order to get the non-contact order? We were told basically that the victim could file that order themselves, but there may be cases in which legal assistance would be necessary. If that is the case, Minister, and my second question is this, will in every case there be legal aid available to the victim in order to secure necessary protection through a non-contact order? Or will there be cases where the victim has to go to some expense, usually herself, in order to get protection against the offender? I think it's really important that we should try to eliminate costs that might be imposed on the victim. The victim didn't ask to be a victim. This is a way of providing protection for the victim, but I'd hate to think that there were victims that were discouraged from seeking a non-contact order because there were financial barriers in the way of them getting that assistance. So I hope you've got both of those questions, Minister. I know in the last bill you made a real effort to answer those questions, and I'd appreciate you addressing those two questions. I want to finish with this. This bill is a better bill because the proposals made by the Labor Party in the Select Committee were adopted. I thank the Select Committee for agreeing to that. I even thank the Minister for agreeing to that. This bill now provides some real protection.
I call the honourable member Dennis O'Rourke.
Thank you, Mr Chairman. This bill is one of a number of moves needed